You're live.
Right. Good morning. We are in Senate Judiciary. It's January 15th. We are returning to Prop 4, which is a constitutional amendment. These amendments require two biennia to go through, and now we're on the second biennium where we will be in the second phase. Working on this prop, prepared for this amendment to the Constitution. So we have scheduled today to walk through a general overview of what it does and what it doesn't do. And we have led counsel and residents to do this, and the floor is yours, Aaron.
Thank you. Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, as the chair said, here to do a walkthrough of proposal for a proposed amendment to the Vermont State Constitution. This is round 2 of Prop 4. I actually looked at some of the YouTube videos of my walkthrough of this bill 2 years ago, so to refresh my own recollection. But you may recall that it was actually April 10th, 2024, when this committee voted out Prop 4 for the first time, voted out unanimously, 5-0. It was introduced on the Senate floor on May, actually it had been introduced in May of 2023, and then it was passed unanimously in the Senate on April 23rd, 2024. It was 29-0 because there was one absence that day, but so it was passed with the consent of everybody present, 29-0. And that was important that had that number, at least as far as being more than 2/3, because the first year of the biennium, the constitutional amendment requires a 2/3 majority in the Senate. It can't just be a simple majority. So it achieved that by far, obviously. Then went over to the House, where only a simple majority is required, and it passed the House on May 8th of 2024 with a vote of 140-4. So not quite unanimous, but very close. And then that was the required vote of the first biennium. So the way the constitutional approval procedure works in Vermont, it requires approval by the legislature in 2 separate bienniums. So since that was the first year of the previous biennium, it couldn't be done again during the second year. You had to wait until this biennium, which is why you're here now, looking at Prop 4 again. Now, assuming, again, not knowing for certain, but based on the votes, be reasonably sure that this will pass, because also during the second vote in the Senate, it doesn't require a 2/3 majority anymore. Simple majority, the second time around. So simple majority in the House again, as it was the first time, and if that happens in both bodies, then it goes to the voters of Vermont. Simple majority required by the statewide electorate, and that would happen this coming November 2026, assuming that it passes legislature this second time around. Senator Rose.
I have a question, and it's not because I think this will happen, it's just because I'm curious, but constitutional amendments are not vetoable, are they?
Correct. That's right. It's up or down. And if it passes all those steps that I just mentioned, it must be approved by the governor as well.
Like I said, I don't think this will happen. I'm just curious.
Yeah, it's interesting because the process doesn't happen all the time, and I had to refresh my own recollection for it as well. So,
and the amendment is not editable at this point, correct?
That's also true. Yeah, I remember last time, you may recall 2 years ago, that the version as was introduced was not the version that ultimately, I may originally sort of gets into the substance a little bit for a moment, but as Senator Hashim was mentioning, the gist of the substance is that it is a state equal protection clause, comparable to equal protection clause that exists in the 14th Amendment to the United States Constitution and equal protection clauses that exist in other state constitutions. But as originally drafted, and in fact had been introduced once before in 2018, now, when you look at the language, it's a standalone separate equal protection clause. You may recall that originally the language was folded into the existing common benefits clause of the Vermont Constitution, which that's the clause that the Supreme Court of Vermont has used over time in equal protection sort of situations, but it's it is a rough fit. And the court has even commented in the Baker decision that established sort of set the ball in motion for the creation of civil unions and marriage equality. The court noted that the common benefits clause wasn't originally intended as an equal protection clause, and I think that's part of the rationale from the witnesses that the committee heard 2 years ago, and from the committee discussion for the need to have a separate freestanding equal protection clause like you have in the version of the language that you approved in 2024 and which you're looking at again today. So the posture that it's in now only requires a majority vote of this committee, a majority vote on the Senate floor. And as Senator Vyhovsky was mentioning, the language has not been changed and cannot be changed. It is what it was then, and it's the same language that you have in front of you today. So we can take a quick look at that, unless there were any more sort of background questions first. So the language has a statement of purpose on the first page. I'm not going to review all that, but really the first sentence of the statement of purpose will lead you nicely into substantive language on page 2. States out what the proposal would do. It would amend the Constitution of the state of Vermont to specify that the government must not deny equal treatment under the law on account of a person's, and then you have the listed protected categories: person's race, ethnicity, sex, religion, disability, sexual orientation, gender identity, gender expression, or national origin. Now you can see those protected classes repeated over on page 2 when you move on from the statement of purpose to the actual substantive provision. So this is the language that the voters will be voting on. And that starts on, at least on my version, line 10 of page 2. That's where it sets out the new article that should be added to chapter 1 of the Constitution, Article 23. And that begins on line 11.
It would just be the amendment that would go on the ballot, not the statement of purpose, or does the statement of purpose go there as well?
I'm pretty sure that's just the amendment, although interestingly, and this I thought was either a question that, if you want to hear from the Secretary of State's office or I can reach out, but I was looking at the statute in the Secretary of State's statutory language that provides what it is that goes on the ballot. And it's interesting, it says that Secretary of State shall prepare copies of the proposal or proposals of amendment and forward them with a summary of proposed changes for publication in at least 2 newspapers having general circulation in the state as determined by the Secretary of State. So it just was interesting. I am not familiar with where that summary comes from. I think obviously it would come from the Secretary of State's office, but would they use that you're sort of kind of getting at, Senator Vyhovsky, maybe the statement of purpose could be included in that summary. It's not what's voted on, but the statute requires the SOS to provide not only the language itself, but a summary. So maybe their office drafts that and provides it to the voters for purposes of learning, explaining what it is they're voting on.
And is that just available on the Secretary of State's website, or is that mailed to every voter with their ballot? Is it available at the polling location? Like, how does the voter get access to this? And maybe this is a question for the Secretary of State, and we should bring them in.
The way I read it, it's published with the language of amendment. So in other words, I don't think, not necessarily that they might do this anyway, but the way I read the language, the summary is published in the newspapers along with the language itself. In other words, not mailed to every voter necessarily or available at a polling place. Not to say that that would be prohibited, but the language at least seems to require the publication of these publications. Yeah, again, substantive language again. Secretary of State shall, between September 21st and October 1st, in any year in which a vote on ratification of an article of amendment is taken, this year in other words, prepare copies of the proposal of amendment and forward them with a summary of proposed changes for publication in at least 2 newspapers having general circulation in the state as determined by the Secretary of State. The proposal shall be so published once each week for 3 successive weeks in each of the papers at the expense of the state and on the websites of the General Assembly and the Office of the Secretary of State. So that would seem to suggest that that's where the summaries are as well. And then the Secretary of State shall cause ballots to be prepared for a vote by the voters of the state upon the proposal. Interesting.
So, Eric, I see that I'm working from draft 3.1 and you have approved by the Senate.
Adopted by the Senate, yeah.
I'm not sure if there's a difference. Do we have copies of them?
What I did, I just grabbed the folders that we had from the last biennium, so I don't know if they've been updated.
And I don't know if there's a difference between
Just to be on the safe side, we
What's the doc number at the bottom?
reprint, the same copies that you printed for Matt, Senator Matos, Mr. Prayer, thank you. And if I could also sign,
I think it's maybe the same subject.
Okay. I mean, in a sense, it doesn't really matter because we're not marking up or changing anything.
Yeah,
But-
yeah.
But,
We'll be getting fresh copies here.
Okay.
right. Henry, do you want this doc to use as a, do you have it already? You can order a doc number. So that's, we were talking about procedure for a moment, right? And the publication of both the amendment and the summary. So the substance of the amendment really is, as I mentioned, it's an equal protection clause. So basically saying that the government needs to treat people equally when they're members of certain protected classes, so that the protected classes are identified for purposes of proposal 4. We see those, we went through with the statement of purpose already, but if you look at lines 12 through 15, you see the introductory sentence that the people are guaranteed equal protection under the law. The state shall not deny equal treatment under the law on account of a person's race, ethnicity, sex, religion, disability, sexual orientation, gender identity, gender expression, or the national origin. So a couple of points about that language. You see that it's the first two words of that sentence are the state shall, right? So this doesn't apply to private actors. It applies to original constitutional interpretation. It requires state action. Now, private actors would be covered by separate statutes, state civil rights law that say would apply to employment and rental housing, that sort of thing, but wouldn't be covered by this constitutional provision, which only applies to state action. Also, the fact that the protected classes are laid out there is important to keep in mind for a couple of reasons. It's good to know that, for example, the federal equal protection clause does not say anything about any particular protected classes. It's just a general principle of equal protection. Government shall not deny equal protection under the law. And so it has been up to the courts over time to determine which classes are received sort of protected or heightened scrutiny. In other words, more of a burden on the state to justify a different treatment on the basis of race, gender, sexual orientation, etc. On the other hand, as I mentioned, there's probably in the neighborhood of 24 other states that have state constitutional provisions already similar to this equal protection. And the approach of the states has generally been to state specifically what classes are protected, as opposed to the federal approach, which is been to lay out the principle of equal protection rather than identifying classes. And another point about the state provisions, which may or may not be why the classes are laid out specifically, is that they are, the federal one is 250 years old, whereas the state ones are done regularly over time. Some of them have been done fairly recently, just as a proof. Pardon me?
I'm just wondering, and I see what you're saying. I'm wondering about the placement of that first sentence and the second. So the first sentence says equal protection under the law, which would seem to take in all laws, right? And then the second one, as you say, is restricted to the state, shall not do X. Does that first sentence give increased protection beyond just the state?
I don't think so.
Okay.
No, I think that's more of a statement of almost like not the catch line as in line 11, describing what is in the paragraph, but it is more analogous to that, I think. It's sort of a general principle that then what follows is the operative language as to what's prohibited. That's the way I would read it.
Okay.
The final word on that is going to be with the Vermont Supreme Court. So I may not be right, but I think that's the way I would read that. Because generally speaking, the constitutional provision requires state action. So on sort of a jumping off point to what you're raising, though, Senator Baruch, is that a question that you may recall coming up 2 years ago is, well, what about that list of protected classes? Is that finite? Is that limited in perpetuity because that's the only classes that are listed? So in other words, let's say there's some member of some other class that's not listed who 10 years down the road, if this passes, wants to bring an action and say, well, I was denied equal treatment on the basis of my membership in this class, and that should be a constitutional protection, even though it's not listed there. And the answer to that is, although there hasn't been a ton of case law on it, there is a Connecticut Supreme Court case interpreting the Connecticut Constitution, so right on point, that exact question. And the Connecticut Supreme Court said, no, that list is not inclusive. It's meant to be an example of classes that are protected, but that in the future, the way constitutions evolve over time and are interpreted, that does not restrict the ability of someone to make a claim based on their membership in a class that isn't listed in the provision. So it's been a couple of years where committee talked about that quite a bit back then as well. And I think the second sentence supports that principle. You see that provides a sort of non-exclusivity kind of concept there. Nothing in this article shall be interpreted or applied to prevent the adoption or implementation of measures intended to provide equality of treatment and opportunity for members of groups that have historically been subject to discrimination.
Sorry, I remain a little concerned that I'm not looking at what Eric is talking about. I don't have the S approved by the Senate. I thought that was being printed out.
Yes, it was. I have.
Okay.
Gave me a copy. Can I take a look at it? I just gave it under for time.
Yeah. All right. Oh, how you were. Oh, first. Okay, it's actually. Saying, oh, that's draft 3.1.
Yeah.
No, Eric is looking at as approved by the Senate.
Right.
Again, and his line numbers are different.
Change that right now. That was, sorry, I told you to print the wrong thing. My mistake.
No problem.
Yeah, I got an extra one here. Unless you had the one already.
I'll take this.
Okay. I was looking at page 2.
It looks like the language is the same, but the page numbers or the line numbers are.
Right. Makes sense. So, just for another minute or two of background, it's interesting to know also that, as I was mentioning, the other state constitutional provisions are oftentimes more recent and involve protected classes that are similar to the ones they're looking at. Some have other classes, some have some in addition, or not as many as are in the Vermont list, but just as an example, Connecticut's 1974 protected religion, race, color, ancestry, national origin, sex, or physical or mental disability. Michigan, more recent, 2006, race, sex, color, ethnicity, national origin, public education, or public contracting. So the different states have different classes listed. Arizona, race, sex, color, ethnicity, national origin. So the different state provisions illustrate that I think there have been different approaches taken, but conceptually it's very much in the lines of what Vermont said, which is to name the equal protection concept and then list the particular protected classes, knowing that in the future there may be claims made that don't fall under one of those listed protected classes, but would still get equal protection in the treatment. The other last point I mentioned is that you'll notice that the constitutional language doesn't say anything about a remedy. Right? It states what is prohibited, but it doesn't say, and if somebody violates this, what happens then? That is something that will be developed in the courts, but historically speaking, and I think it's familiar with claims that have been made under existing provisions of the state and federal constitution, that a person who claims a violation can seek an injunction in court. In other words, an order from the court saying that this unconstitutional conduct must stop. The question that is a little less clear is that whether or not that same person could seek a remedy in damages. But that person also say, I've been discriminated against on the, or been treated, my equal protection rights have been violated on the basis of my particular category you see listed there, and therefore I'm asking for a claim in damages on the basis of the harm that I suffered. And the Supreme Court in Vermont has a sort of a test that's to determine whether or not a constitutional provision necessarily comes with a right to bring an action for damages. So I think that would also be developed over time during the course. But I think the committee made a decision that in keeping with the way constitutional provisions are generally written, that the remedy is set out that that's left for future cases. So I think that's the substance of the walkthrough. You'll see the effective date. It becomes a part of the Constitution on the first Tuesday after the first Monday of November, obviously tied to the election date. I'm not sure what the election date is this coming November, but it will be the first Tuesday after the first Monday after ratification. And as I mentioned, it needs a simple majority both in this committee and on the Senate floor and in the House. And if that's the case, then it would go to the voters later this year.
Eric, one piece I was hoping you could touch on is the question of what determines whether a case goes to a state Supreme Court versus the US Supreme Court.
Right. Yes, excellent question. Thank you, Senator Sheen. And puts a case in federal court. One of the ways that a case can get in the federal court is what's known as excuse me, sorry about that, a federal question. And that, for example, would be a question of federal constitutional law. So the federal courts and ultimately the United States Supreme Court has the final say on interpreting a provision of the federal constitution, of the federal, in this case, an analog of the Federal Equal Protection Clause. The last word on that is in the federal court system, and the final word in the federal court system is the U.S. Supreme Court. However, because this is not a federal constitutional provision at all, it's an amendment to the state constitution. There is no jurisdiction in federal courts for there to be a decision from the federal court saying what that provision means, what to interpret it is what it means. The final say on what the state constitutional provision means is with the Vermont Supreme Court. And for example, if someone had purely a state a claim under the Article 23 for equal protection, and they wanted to bring a claim in court based solely on that, the federal courts wouldn't even have jurisdiction to take that question, assuming that there weren't citizens from different states, that sort of thing. That might be a little bit of a wrinkle to that. But again, final word on interpreting what Article 23 and any other provision of the state constitution means is with the Vermont Supreme Court, not the federal courts. I think is what you were getting. Is that where you were getting at? Senator Sheep?
Turn both.
Just a bit of a follow-up, and I seem to be asking this question a lot lately, and that is, and so there is no interplay in this between the state Supreme Court and the federal Supreme Court. So if someone took it to the state Supreme Court, there's no world in which they could get a result there that they didn't like and then say, actually, we want to take the whole thing to the federal court.
Assuming it was just a state constitutional provision that they were litigating, yes.
Could they challenge the state constitutional provision on the grounds that it is not aligned with the US Constitution in the federal Supreme Court?
There is some history, there's some history in that, yes, that, and I can't remember the exact issue, but I do recall within the last few years that issue be coming up in the sense of what controls, what trumps in a situation of let's say you do have that situation where you have a state constitutional provision that's contrary to a federal one, because you could see the argument on both sides of that, right, in a federalist system. But if I remember correctly, and I'll look into this a little more, I think the ruling there was that that it's federal provision of precedent.
But the
Direct conflict.
would the court have to rule that there in fact is a direct conflict?
Yes.
Because I think sometimes when someone looks at the language, they might feel there is, but that doesn't necessarily mean there is.
Correct.
So that would be the only world in which we would see a state constitutional issue go to the federal level, potentially.
Right, someone might argue that the state constitutional provision was somehow,
Unconstitutional.
yes, not federally constitutional. But as you say, that requires that initial conflict to exist in the first place, which you can imagine ways that this might work. For example, which there might be a different interpretation, doesn't mean that it's necessarily in conflict. For example, because I think as is often said, the federal constitutional analysis under the Equal Protection Clause sets a floor, right? That doesn't mean that the state can't be more protected than that. It's not a conflict for the state to be more protected. Imagine an example where, just choosing randomly one of the protected classes that are in the proposed amendment in Article 23. For example, sexual orientation is not listed as a protected class in the federal constitution, right? So a person might argue, try to make a claim under Article 23 and say, look, I'm not being treated equally on the basis of sexual orientation. And for that reason, because it's listed, I think that the state action should be subject to heightened judicial scrutiny. You may recall the phrase, there has to be a compelling interest asserted by the state. Strict scrutiny is the nature of the analysis. There has to be a compelling interest, and the rationale has to be narrowly tailored to serving that compelling interest, least restrictive means. So this very difficult level of judicial scrutiny to reach. For a state constitutional claim, person making up the basis of sexual orientation, the court might say, yes, we're going to apply that strict scrutiny because of the fact that you have this listed group here that you're claiming you were denied equal protection on the basis of. On the other hand, in the federal constitutional case, the Supreme Court and I know that sexual orientation, at least currently, is not a suspect class that gets the most heightened level of prudence. So that would be different, right? If the court, but not impermissible and not a conflict. It's just that the federal courts set a floor. State court could be more protected, but they couldn't be less. That would be if they were saying,
Yeah.
right.
So just to clarify, the state Supreme Court could say, if they wanted to, that they're going to look at a potential unconstitutional law, or you could say disability. They could say we want to look at that with strict scrutiny, or they could say actually we want to look at it with intermediate scrutiny. It's up to the Supreme Court.
Absolutely. No matter what, the federal Supreme, regardless of what the federal Supreme Court had said, was the analysis of the federal constitution. In fact, sex would be a perfect example, because if you on line 14, because we already know that sex gets what's known as intermediate scrutiny under the federal constitution. So it doesn't get strict scrutiny. It gets this sort of middle level between rational basis and strict scrutiny, which I think is an important state interest. And just sort of stated, the middle tier, substantially related to an important government interest. But that's your middle tier. But someone makes a gender claim or a sex-based claim under the state constitution. If this were to pass, it could be heightened scrutiny, could be strict scrutiny. This court might say that, no, we're going to give that sort of classification a more rigorous level of scrutiny than the federal courts gave it under the equal protection clause. And that would be a conflict. It would just be moving them above the floor. Whatever. Answer my question.
You had alluded earlier to the Baker case, and I remember the only question that I got from then Senator McCormick was whether or not the Baker case already covers what we're trying to accomplish with this. Can't remember specifically what my answer was, but if you expand a bit more on how this is different from the Baker case, and did you expand on that?
Well, the Baker case is, as I'm sure Senator McCormick was was asking about and you were discussing with him was decided under the common benefits clause, which existed at the time, and that was, and still exists, which was how the court was looking at claims that were similar to equal protection claims. You know, a member of one class of people is treated differently by the government because of their membership in that class. And the test that the court has developed in Baker and has used in subsequent cases is very different than the sort of standard tests under equal protection clauses that have developed over time. So you have, I think, at least two different ways that it would be different in response to what you're saying, Senator Hashim. In the first place, the proposal here, which is not the case in the common benefits clause, specifically lays out protected classes of people. And specifically, so in other words, you wouldn't have to, if you were going to bring a claim under Baker, would have to first establish that you belong to a particular class that is getting this constitutional protection. That step is already, in a sense, taken for you by virtue of the fact that the language itemizes the 1, 2, 3, 4, 5, 6, 7, 8, 9 or 10 protected classes already. So you wouldn't have that sort of threshold requirement that you would have to establish whether or not that class that you're part of gets some type of judicial scrutiny for whatever state action is taken that you allege denied you equal protection. So I think in that case, it more clearly lays out how it is that you would have standing to bring a claim under the Constitution. And so that's point number one. Point number two is that the strict scrutiny that we're talking about, the intermediate scrutiny, those are tests essentially that have been established by the court for that demand a rationale from the state as to why they have treated people in these different groups differently. But those can be very demanding, particularly with strict scrutiny. That doesn't exist under the common benefits clause analysis either. So we don't know yet how the court would interpret the levels of scrutiny that would apply to each of those listed protected classes in the proposed language of Article 23, because that's just something that's going to be developed by the court over time. So we don't know. But if you think about how those protected classes have been treated over time by other courts and by the US Supreme Court, there's some reason to at least think that some level of more demanding rationale would be required from the state that is required under the common benefits clause by virtue of naming these groups, these classes. So I think that's a couple of ways. I don't recall that particular conversation, but I don't know that. In other words, it's not already covered because you haven't laid out the groups of people in terms of common benefits clause that can bring a claim to this, and more likely that those groups would have a greater level of judicial scrutiny than currently exists. Is that kind of
absolutely. Yeah. Thank you.
Yeah.
Any questions? All right, Eric. Anything else from you?
No, I don't think so. Not at this point, I think.
Great. So that sounds good. Our next witness is at 10. And regarding Prop 4, we are lining up witnesses for next week. And we'll just slowly move through this. We can't make any changes as we know, but we'll still make sure to get on the record from all the folks who want to testify on this. And for folks who are listening, if you'd like to testify, reach out to our committee assistant and squared by. All right. Thank you, Eric.
You bet. Thank you.
We can go off.